morning break. We're glad you're here. We are excited about today's program. We know everybody's swamped these days with openings of pools and tennis courts and gyms. So we appreciate you guys taking a couple minutes with us. We have an exciting program today. Ro Rapani, Chris Lee, Richard Joseph going to talk about the reopening of the courts and what it means for moving your collection cases forward. And we're going to start with Ro. Thank you, guys.
Thanks, Jay, and thank you all for joining us this morning. I hope you're all staying safe and healthy as we move through this. I just wanted to give you a quick update on both the judicial stay that's been in place as well as your collections actions. I'm sure you're starting to see that there are some owners who are not paying in the ongoing crisis, and we just wanted to give you some ideas on how you can move forward and make sure those don't get stagnant. So as far as the actual judicial stay, as I'm sure all of you are aware, back in March, there was a stay enacted, which essentially froze most legal action in the state. It put a hold on all filing deadlines as well as most in-court activity. This has been extended through June 12th. Now, currently, it is set to expire on June 12th, and we don't know for sure that it will be, that it won't be renewed, in either at least in part or in full. But since this does coincide with the lifting of the state of emergency from the governor's office, we are hoping that afterwards there will at least be some traction. So with that in mind, as I said, I'm sure you are seeing some increase in non-paying homeowners, and some of you may have been holding on to your collections actions because you didn't want to move forward during the pandemic. We just want to encourage you at this point that this is a good time to pretty much start moving those forward if you haven't been, and if you have been, to keep moving those forward as well. Essentially, what you want to avoid is a situation where your homeowners get their balances so big that they can't actually work with you to get it taken care of. If the homeowner has missed 1 or 2 payments, that balance will be relatively small. It may still be manageable for them. They can still work something out for you. The problem you're going to face is if you hold on to your collections for up to 6 months is that you're going to have somebody who is so far in the hole they can't work with you at that point, or they're going to be looking at declaring bankruptcy. It's better to get ahead of those in general, but especially now, and get them while the balances are still small. So we do encourage you to move forward with getting your collections actions moving. Another reason to do so, and I believe we discussed this before, is once you send your collections to us, we do get our demand letters out, but more importantly, we get our liens filed for you. When that notice of lien is filed in the county land records, it protects the association a lot more strongly than if it isn't there, even if they are submitted to the Condo Act or the Property Owners Association Act. That notice of lien is going to come in handy, especially now with interest rates changing. You are going to see a lot of homeowners trying to refinance their homes or sell their homes or declare bankruptcy, and the lien will protect you. Now, with that in mind, as I said, you are going to see homeowners who are having trouble paying. You're going to have owners who have told you that they've furloughed or that their payments have been cut or that they may even have them let go. So one thing that we would like to encourage you to work with your association boards and see if you guys can get some sort of deferment or amnesty plan in place. As you get these collections actions going, you want to have some protocols that will allow the association to work with these owners who may be experiencing financial difficulty to basically help them get through the next few months and make sure that they are in a position to keep paying what they can to the association. And then when their circumstances get better or when the pandemic situation gets better, then they can start making higher payments and work towards getting those taken care of. But again, the most important thing is to make sure that you don't let them sit and let those balances get too big. If you get the amnesty plan in place and you get those liens filed, you are going to see that you're going to get at least some traction, whereas before you were getting none. Now, finally, as we said, we are hoping that the judicial stay will expire on June 12th, but even now we are seeing some traction and seeing some cases move forward. I know several members of our department have already had some online hearings, and we are seeing that some courts are allowing us to set some deadlines and maybe push things forward. This is going to be important for us, especially as we start trying to move our lawsuits forward, as well as our post-judgment and bankruptcy, which I believe Chris will be speaking to you now about how we can move forward with our lawsuits and what to expect in that.
Thanks, Ro. And I want to thank everybody out there for tuning in and touching base with us. I know it's been hard to kind of connect. We're here for you, and this is why we wanted to touch base about litigation. I know, as Ro mentioned, a lot of people were concerned about how do we move our cases forward during the pandemic. Well, the second emergency order, which was the updated one, basically gives a lot of words of wisdom to the lower court. It is authorizing judges to reimpose deadlines where those deadlines, as Ro mentioned, were previously suspended or on hold. It also further encourages those courts and those lawyers to find ways to resolve cases promptly, efficiently, but also fairly, because we do want to keep in mind that there are individuals who are hurting and suffering in different financial means. They also encourage in this order remote proceedings. So as Ro mentioned, they're doing video hearings or conference calls, but the key thing is it's so long as it does not impose a burden. Now, again, that goes back to we want to be fair while this is all going on. Now, Chief Justice Melton of the Georgia Supreme Court said more or less, look, we have the cases and they're ready to move, and we have the capacity to do so safely. So let's move them. We see that same sentiment being echoed in the lower courts where we practice in state. A lot of those courts are moving their cases forward to relieve the backlog that they previously experienced due to all of those holds. The courts have been reaching out to us. I know just earlier last week, I received a court email saying, hey, this case was previously in default pre-pandemic. What's the status? What are your intentions? And we've also seen a lot of courts set video hearings, and the hearings are for service, motion for default, motion for summary judgment, and we are getting judgments from those. So hearings are taking place behind the scenes in our own homes or at the office, but without having to go into the courtroom. So you're seeing those cases move again. In addition, we're seeing courts, some courts I should specify, individually take it upon themselves to issue orders implementing deadlines for responses like answers or response to motion to dismiss. But what I want to show to you is the cases are moving forward. So anybody who was previously concerned doesn't have a reason to be. The courts this entire time have been accepting filings. Now, some people may have seen a little bit of a slow or a lag because they were worried about service. And it's true. Some of the sheriff's offices were a little slow on that end, and we were relying heavily on the private process servers. However, we have now seen movement in the direction where private process servers and sheriffs are all serving successfully. So there should be no holdup in filing and waiting for anybody else to serve. We have that in place. Furthermore, we have clients who have continued to file. So people who have been waiting, it's a good time to start now. Get in line now before 2 weeks go by and the June 12th deadline expires and everyone else is rushing to file. Now, I did mention that it's certain courts that have taken it upon themselves to implement those deadlines. I want you to know that at our firm, we're thinking ahead and we want to know, hey, how can we push those other courts forward? Well, we've prepared in our department motions to reimpose deadlines where the courts haven't decided to implement them. We want to make sure those answers are being filed. We want to make sure responding pleadings are being filed. We are doing everything we can to encourage the movement. So again, feel free to reach out to us, ask questions, but there should be no reason to keep holding on to any of those because the court systems are taking affirmative action, as is our office. Now, I know a lot of concern was, hey, Chris, even if we do have those judgments, what happens now? Excuse me. The thing that you have to remember is courts are moving. And now I want to kick it over to Richard, who's going to talk a little bit more about what happens once we have that judgment. He's going to discuss the post-judgment actions and what we can do to collect and continue collecting. Richard?
Thank you, Chris, and thank you, Ro. Good morning to everyone. We're happy to be here with you today, and we hope we can share with you some information that you'll find of use. As Ro and Chris have observed, and I share in that observation, there is a interest in the courts and among the people who staff the courts to move forward as quickly as possible and in a safe way to clear up the backlog of cases that might have developed over the last 2 months or so. Now, with respect to the post-judgment collection, the status of post-judgment collection, we're pleased to say that for many of the judgments which we already had obtained prior to the judicial emergency, we've been able to move forward with collections and garnishment, except with some exceptions. If we filed garnishments prior to the judicial emergency, we received money out of those garnishments just as if the judicial emergency had not taken place. Those garnishments continue to be processed, and the garnishees had to pay money as if there were no judicial emergency. It didn't affect that. With respect to filing new garnishments, there was an effect. The judicial emergency said that the courts could dispense with their everyday business except for essential services, and garnishments were not considered essential. So the courts, to a great extent, stopped accepting new garnishments. However, that has already begun to change, even though judicial emergency has not been completely lifted. And so, for example, Fulton and DeKalb are accepting new garnishment cases, and we're able to move forward with those new garnishments. Gwinnett County is not. We don't anticipate that they will begin accepting new garnishments until the end of the judicial emergency. And of course, garnishment is one of the chief ways that we have to involuntarily collect the debt that's owed to the association. With respect to condominiums and property owners association act communities, of course, we have the option of foreclosure. Some of you might have given us authorization to proceed with foreclosure in the last month or so, or even 2 or 3 months earlier. All of that activity did cease. There have been no public sales at the courthouses, and so foreclosure sales have not been scheduled. It appears that we will start seeing foreclosure sales scheduled beginning maybe in August. We're hearing back from sheriff's offices who coordinate the sales, and we know that they're working on scheduling the sales, and they've assured us that they will get them scheduled as soon as possible. We do know that Cobb has tax sales scheduled for July, so that's the sign that Cobb is moving quickly to resume public sales, which would include foreclosures under both the Condominium Act and the Property Owners Association Act. We anticipate that there will be a number of bankruptcies. And of course, bankruptcies can occur at any stage of the collections process. A certain number of people will file bankruptcy when you make a demand on them. A certain amount of people will file when you file suit. Once you get a judgment, and once you start collecting the judgment or foreclosing, of course, that will force other people into bankruptcy. Bankruptcy courts have not been under any sort of judicial emergency. They have operated pretty much as they did before the pandemic hit our area. So they have conducted business by telephone conferences and online conferences such as this. Debtors who file Chapter 13 cases where they have to make debt payment are still required to make their payments to the trustee to pay claims. They're not relieved of that obligation unless they get the permission of the court, and that's been occurring. Owners who flee to Chapter 13 as a protection against collection efforts won't be able to stay there long if they can't fund Chapter 13 plans and if they're not paying post-petition assessments. So that they really are if it is a safe haven, it won't be a safe haven for long if they can't discharge their obligations to do that. So it's important for when you receive a notice of a bankruptcy case to get that to us as quickly as possible so that we can act to protect the rights of the association, particularly with respect to filing a proof of claim in a Chapter 13 case, and if appropriate, filing an objection to confirmation. If they're not current with post-petition mortgage and HOA payments, their Chapter 13 plans will not be confirmed and their cases will most likely be dismissed promptly. Now, of course, for Chapter 7 cases where there is no debt repayment, I suspect we'll see more of those, and people can file those and they will be able to stop garnishment or involuntary collection efforts. However, as you might have seen in the past, a Chapter 7 case does not eliminate the remedy of foreclosure for condominiums and under the Property Owners Association Act. Even after the debt is discharged, we will still have the option of foreclosing the statutory lien and enforcing the association's rights in order to collect the debt. So that's pretty much what I had set to share with you today. Again, thank you for joining us and thank you for your attention. And I guess I'll turn it back over to Jay.
Thanks, Ro, Chris, and Richard. So those of you who know me know I like to give you something practical to take away from these. And we have a couple today. One is with the shutdown of the courts, most people that have claims, lawsuits have been waiting. They've not been doing anything with it. And you guys have seen this. Courts were already overtaxed and had trouble keeping up with loads. They are going to be swamped with new filings, new claims over the next several months. And it's probably going to overwhelm them. And it is much better for us to be started before they get overwhelmed with the new filing. So important to move quickly. That's especially important now because while we know we have people who are recurring regular delinquents, we're also seeing a lot of other ones that take time to talk through with people, and they're owners who don't want to pay because you may have had your tennis courts closed for a month or your pool opened 2 weeks late. And absolutely, we talk with those people and try to explain and get them to pay. And obviously, legally, they have to pay. But those kind of things can easily make us delay the process of getting collection started in the courts. And it's important that we remember that we try to get through those quickly. And if we don't get them resolved, start the collections, get them in court. Otherwise, we're going to be waiting with tens of thousands of others to get their cases processed. The other thing that we hope out of this is, frankly, we all love that the judges are now doing hearings by videos, and hopefully that continues forever because that'll make things move much faster for the future. All right, a couple of other things. If you have missed our other morning breaks, we have the videos posted online at our website, ljlaw.com, and feel free to share those with your boards. This one will be up in a couple of days, and we have several others. We also have posted, you may have gotten our e-blast last week, a sample waiver release agreement for using amenities and sample signage for pools, tennis courts, and other. Let you share those with your boards of directors. We also have on the website much more detailed information on bankruptcy and foreclosures. Those are tricky issues and boards don't always understand how they work. So if you want to grab our articles or quick facts on foreclosure, bankruptcy, collections, feel free to grab those online. If you have questions, you guys know you can always reach out to us. Call, email, we love hearing from you. If you have questions on this program, we're going to keep it open for a couple more minutes after we sign off. You can send those questions on the menu bar on the side of your screen, and we will get back to you with those. And hopefully we'll see you soon. We miss you guys, so stay safe. Thanks for joining us.